Baruch Chait's melody. It's always hard for me to turn it off. I love it so much. How's everybody doing? Great to be learning with you on a Tuesday. And for our friends who are celebrating Christmas, we wish them a Merry Christmas. There is a tradition that some may be familiar with called Nittelnacht, which is actually a Jewish tradition on Christmas Eve. And it sadly exists because this was a very dangerous night for Jews in Europe in medieval times. Sadly, there were places where they really hated the Jews, and in the church that night they would preach sermons about how the Jews had done wickedness to their faith, to the Christian faith on this night, and people would get riled up, go out, riot, mob, Jews would get killed. And so it was a night of laying low, and a dangerous night for Jews, and there actually was a tradition not to learn Torah on this night. Jews would often tell stories or play chess, etc. So it is not a halacha. It is not universal. But there are large Jewish communities that are not studying Torah on this night because of this Nittelnacht tradition. There's many other communities that are learning Torah on this night like every other night. And I made the decision to learn because I feel like Daf Yomi just requires learning every other night. And thank God we live in a time and a place. So there are many Jew haters in the world. There are many hateful people. There is danger to Jews. And I've talked to you many times about Maganam and how we take security seriously in our community. Nonetheless, we're so grateful to live in America, if you live in America, or in a place where you live, where for the most part Jews are safe. And we have friends, we have allies, we love you, we appreciate you, and may you be blessed in your path to God, and may we be blessed in ours. And this is such an important part of our path with and to God. So, who's in the house on a Tuesday night? with us. Melissa in Great Neck, Yehudit in Myrtle Beach, South Carolina. Bella in Florida. Bill in mid-Missouri. Joe in the Inland Empire. Shandor in the Bronx. Guy in Ohio. Jonathan in Ventura. Lucy in Minnesota. Nancy in North Carolina. Stephen in New Hampshire. John in Maine. Lorraine in Texas. Barb in Massachusetts. Chaim in Florida. Marie in Freeport. Aoife in Florida. Marjorie in Georgia. Ella in Southern California. And I gotta tell you, we got a great daf tonight. This page 6 here in Tractate Sanhedrin, the 24th volume of the Talmud, continuing our discussion of Mishna number 1. In chapter 1 of Tractate Sanhedrin, generally this Mishnah is about the composition of courts for various types of cases. And as you'll see tonight, as we get into what kind of judgment these judges are called on to provide, what is the difference between judgment, mediation, compromise? Fascinating, absolutely fascinating daf. So let's dive in. We're right near the top of page 6a. So since it was meant... Nina, you were like about to come, right? Let's light up the darkness. Since it was mentioned incidentally, the Gemara discusses the matter itself. Rabbi Abahu says, with regard to a court of 2 judges that adjudicated cases of monetary law of any type, which would include cases of admissions and loans, right? So monetary loan, first we said, robbery, when somebody's property gets stolen and we want to get it returned to him. Damages in cases of injury. Contract disputes for loans that have been paid or haven't been paid. All these kinds of cases require 3 judges. Well, what if you don't have 3 judges? Is it a valid judgment or not? So regarding these cases, everyone agrees that if 2 judges adjudicated a case of monetary law, everyone agrees that their judgment is not a valid judgment because there were not 3 judges. Rabbi Abba raised an objection to Rabbi Abahu from a Mishnah, Tractate Bechoros 28b. If a single judge, just one judge, adjudicated a case of monetary law, and he erroneously exonerated the litigant who should have been deemed liable, or he deemed liable the litigant who should have been deemed exempt, or if one issued a halakhic ruling whereby he deemed ritually impure that which is actually pure, or he deemed pure that which is actually impure, well, what he did is done. His ruling is binding. And the judge pays from his house. Fascinating. So if there was a single judge and he judged a case and he made a mistake, okay, so let's say that I was suing Johnny for $1,000 and the judge said, Sal, you owe Johnny $1,000. And later it turns out that he made a mistake. Now, when he said, Sal, you owe Johnny $1,000, I paid Johnny. And then later it came out that the judge made a mistake. Johnny was not entitled to $1,000. The money should have stayed with me. The judge has to make it good from his own funds. He's going to owe me $1,000. Or if I haven't already paid Johnny, he's going to have to pay Johnny the $1,000. Johnny shouldn't have won that trial. But what the judge did is done. But the judge has to make it right from his own pocket. Imagine if judges were held to that standard, how careful they would be to always get the law correctly and not be swayed by anything but the law and the proper application of the law. So that's in the case of one judge. So even though he made a mistake, his ruling is binding. He has to pay Johnny. Johnny never should have got anything. But now that the judge said Johnny gets the verdict, Johnny gets $1,000 and he gets it from the judge. Now, the Gemara responds, so what about that? So if that's a case, so the verdict is binding even on one judge, why do you say that if there's 2 judges and they issue a verdict that it is not a valid judgment at all? It sounds like the judgment of one judge is binding. So the Gemara responds, here we are dealing with a case where the litigants accepted this singular judge, this lone judge, upon themselves, and it is for that reason that his ruling is binding. Otherwise, it would not be binding. As a halakhic court, a proper beis din, a rabbinic court, must contain a minimum of 3 judges, right? So they submitted to the authority of this single judge. If they were brought to court If one of them submitted and the other one was compelled to come and he never submitted willingly, so then if it was a judgment by one judge or two judges, anything less than three, he could skate because then it would not be a valid judgment. But if they're both litigants, both sides submitted to the authority of the single judge, then that is why it is binding. Says the Gemara here in response. Here we're dealing with a case where the litigants accepted the singular judge upon themselves. And it is for that reason that the ruling is binding. Otherwise, it would not be binding. So the Gemara asks, if so, that the litigants agreed to accept whatever ruling the judge issued, why must the judge pay from his own house? Why must he make it good? And the Gemara answers, well, the judge is liable because the case is where they said to him, adjudicate the case for us according to Torah law. If he made a mistake, he didn't adjudicate according to Torah law. So we might say, well, then why does it stand? We submit it to him, and so we accept his ruling, but if it's not according to Torah law, it's going to have to come out of his own pocket. Rav Safra said to Rabbi Abba, the ruling applies when he erred in what respect? What kind of mistake did he make that it resulted in Johnny getting a verdict for $1,000 that he wouldn't have got otherwise? What kind of mistake produced this? If we say that the judge erred in a matter that appears in the Mishna, and he mistakenly ruled against an explicitly stated halacha, an explicitly stated law that's in the Mishnah, well, then this is difficult. But doesn't Rav Sheshes say that Rabbi Ami says, if the judge erred in a matter that appears in the Mishnah, the decision is revoked and the case is retried, right? So if he ruled against what it says in the Mishnah, then no, Johnny doesn't get the money. The whole thing is thrown out and it has to be redone. We don't accept his verdict because it contradicts the Mishnah. So it must be some other kind of error than contradicting an explicit law in the Mishnah. Appears in the Mishnah. It is revoked and retried. So rather, the case is where he erred in his deliberation. Okay, what does that mean? The Gemara asks, what are the circumstances of an error of deliberation? Rav Papa said the circumstances of an error in deliberation are where, for example, there are two Tanaim or two Amoraim, two sages of the period of the Mishnah, or two sages of the later period of the Gemara, who disagree with one another. And the law was not stated in accordance with the opinion of one sage or with the opinion of the other. It doesn't say in the Mishnah or in the Gemara which opinion we should follow. It's never explicitly stated what the law is in the Mishnah. There are two sages, and we don't know where that argument came out just by reading the Mishnah or even just by reading the Gemara. But the standard practice among all competent judges is to rule in accordance with the opinion of one of those sages in that debate that was captured in the Gemara. And this judge who made a mistake, he went and executed the judgment in accordance with the other opinion. Right? So it was never stated in the Mishnah or the Gemara where the halakha ended up based on this debate. But later than the Mishnah or the Gemara, right? Later sages, that's why we have the period of the Geonim and the Acharonim and the Rishonim, the Geonim, the Rishonim, and the Acharonim, right? The sages from the years 500 to 1,000, the sages from the year 1,000 to 1,500, and the sages ever since. You know, over that period of time, by the time of Shulchan Aruch, we have what the law is, even if it wasn't stated explicitly in the Mishnah. So, if somebody followed what was an opinion in the Talmud, but has not become halacha, and he violated that, that would be called an error of deliberation. And so presumably the judgment would stand, but he'd have to pay for it out of his own pocket because he didn't know what the law was in standard practice. Now the Gemara suggests, let us say that the dispute between Shmuel and Rabbi Bahu about a court composed of two judges, and is that a valid verdict or not, is parallel to a dispute between the Tanaim, the sages of the Mishnah, as detailed in the following Baraisa. Mediation can be performed by a panel of three judges. This is the statement of Rabbi Meir, and the rabbis say compromise can be performed by even a single judge. And the sages assume that everyone agrees that we compare compromise to judgment and require the same amount of judges for this process. So somebody assumed that. Now there's these two words, okay? So one is bitzua, and this is, we're going to translate as mediation, and peshara, which we're going to translate as compromise. Both of these are extrajudicial processes, meaning it is not getting a judgment from a beis din, from a rabbinic court. Instead, you're either doing mediation, bitzua, or compromise, peshara. They're sort of the same and sort of not, right? Both of them indicate some kind of arbitration, some kind of the two parties want to come up with an agreement and they want to be advised in this, by a judge-like authority, right? Somebody who has the status of a judge but isn't rendering judgment. That's why this could be done before one judge. And they're just committed to working it out and not having a drawn-out trial. So what's the difference between them? Seems like bitzua, which can be referred to splitting the matter, or it can be referred to greed, as we'll see, means a very precise arrival at what exactly would the judgment be? That's what we're going to agree to. It's very similar to a judgment. Whereas peshara is, let's just come up with something that makes everybody happy. And we're not going to delve too much into precisely what it should have been. If we can come up with something that everyone's happy, that's more compromise, that's peshara. So bitzua is a little more precise, peshara is a little bit more easygoing compromise. Now, and these don't require 3 judges, according to some opinions, and according to other opinions, they do require 3 judges. So let's keep going. And what? Is it not that they disagree in this matter that one sage, Rabbi Meir, holds that judgment, so judgment is proper judgment according to Torah law by the beis din. Rabbi Meir holds that judgment and compromise can be performed by a minimum of 3 judges. And the other sage in this dispute, the rabbis, the majority who disagree with Rabbi Meir, hold that that judgment and compromise can be performed even by 2 judges? Is that what we're saying? Gemara says, no, that's not what we're saying. It is that everyone holds that judgment must be performed by a minimum of 3 judges. We've seen that over and over. And here they disagree with regard to this. One sage, Rabbi Meir, holds that we compare compromise to judgment, and the other sage, the rabbis, hold that we do not compare compromise, peshara, to din, judgment. So the Gemara suggests, let us say that there are 3 opinions of Tanaim with regard to mediation leading to compromise. So one sage, Rabbi Meir, holds that mediation, bitzua, this more precise form, mediation must be performed by a panel of 3 judges. And another sage, Rabban Shimon ben Gamliel, holds that it can be performed by 2 judges. And then the third opinion, which is the rabbis, holds that it can be performed even by a single judge because it's not din. Now we're talking about bitzua, but bitzua and peshara both can seemingly, according to the majority, be done by a single judge. Now, the Gemara rejects this idea of, 3 opinions, one that it requires, that bitzua requires 3 judges, another that it requires 2 judges, and the third that it requires 1 judge, minimum. So now the Gemara rejects this understanding and says the following. Rav Acha, the son of Rav Ika, and some say Rabbi Yemar bar Shalamia, said, the one who says mediation must be performed by 2 judges would say that it may be performed by even 1. And the reason that he says 2 is merely that there would be 2 witnesses, right? When they're saying once you don't need 3, really you can do it with 1. But the reason we ask for 2 is so that at the end of the day, who was there? There were 2 litigants and 2 judges. The 2 litigants are having the argument. They come up with this compromise arrangement. And then it's better to have 2 judges than 1 because you will have 2 witnesses to the compromise. So later they can testify as to exactly what was the compromise that they agreed on. Not because you need 2 judges, but it's better to have 2 judges because then you'll have 2 witnesses. Rav Ashi says, learn from that discussion that compromise, peshara, does not require a kinyan, a formal act of acquisition, which would legally transfer rights to the settlement payment to the other party. In other words, they are formally submitting to the authority of this compromise by making a kinyan, some kind of formal act of acquisition, right? I mean, basically, it's one is getting paid from the other, one is trying to extract money from the other. So we make him give some kind of a kinyan, like that both of them have submitted to this, and whatever the outcome is, they're going to accept it, and that they formally accept that they're participating in it. So they have to make some kind of a kinyan, like a transfer of a handkerchief or something, some formal act of acquisition. Why? As if it enters your mind that compromise requires a kinyan to finalize its terms. According to the one who says it requires a kinyan, why do I need a formal court of 3 judges? Let it suffice with 2 judges, and let one litigant perform a kinyan with the other litigant to signify their commitment to abide by the compromise. They're in, they accept it, they're submitting to the authority of the single or the 2 judges, and they don't need a beis, they don't need 3. Now, if a kinyan is required to grant halachic force, right, and forcibility to their compromise, then there is no advantage to having a panel of 3 judges with the status of a formal court. Once they've submitted to it, you don't need 3, you could do it 2 or even 1. And the Gemara concludes, but nevertheless, the law is that compromise does require a kinyan to finalize its terms, presumably even if you had 3 judges. Now, the sages taught in a baraisa, because still it wouldn't, even if you had 3 judges, it wouldn't be the process of a beis, it's the process of peshara. And if you have less than 3 judges, all the more so you want that kinyan, just so that it could be remembered and witnessed that both parties submitted to that authority. Now, the sages taught in a baraisa, just as judgment is performed by 3 judges, so too bitzua, like mediation, the stricter form of, some kind of arbitration. The stricter one is bitzua, mediation, and the more easygoing one is peshara, compromise. Okay, so just as judgment is performed by 3 judges, so too bitzua is performed by 3 judges. Now we're on page 6b. Once the verdict of the judgment, right, din, from a beis, has been issued, it is not permitted for you to mediate a dispute. If they go through the process of beis and they get a din, now it's too late to mediate, right? What you could start beis, and then they could decide, I'm not sure how this is going to turn out. It's getting ugly. Testimony, witnesses. Let's just compromise, okay? And if there hasn't been a din yet, even though they went before a beis, but the beis hasn't given their din, their judgment, so then it's not too late to enter the process of bitzua. Now, the Gemara presents a mnemonic device alluding to the names of the Tanaim in the coming discussion to help, if you were memorizing all this, to help you remember who says what. Samech Reish Mem Shin Beis Nun Kaf Shin. And the Tosefta cites several statements of Tanaim related to compromise and the term botzea. So bitzua related to botzea. Rabbi Eliezer, the son of Rabbi Yosei HaGalili, says, it is prohibited to mediate a dispute. And anyone who mediates, which he says habotzea, anyone who mediates a dispute is a sinner. And anyone who blesses the mediator is cursing God. And of this it is stated, quote, and the covetous, botzea, blesses himself though he despises the Lord. So interesting, the covetous, somebody who covets something else. Why would this be coming up? We know that coveting is a sin. So what's going on is bitzua, right, where you're splitting it precisely. What you're saying is the plaintiff in the case who says, I'm owed money. So he is coveting, legally perhaps, right? If he's right, he wants money from the defendant that he believes he's entitled to. But bottom line, he wants that money. He wants it from the defendant, and maybe he's legally entitled to it. But if he's not legally entitled to it, if we had perfect justice and we understood exactly God's will and everything, then maybe he's not entitled to it. And it's only because it was a mistake of law, or this guy just thinks, but until we get a proper judgment, he wants, right? And so it's the same word as covetous, somebody who covets. In Psalm 10, right, it says, and the covetous, the botzea, blesses himself, though he despises the Lord. So it's almost that sense of somebody who comes in the name of God to get what's his, and really he just wants what his because he's greedy and he hasn't really explored the law. He needs a judge to do it for him, but he thinks he's entitled. So rather, and so according to this opinion, Rabbi Eliezer, the son of Rabbi Yosef HaGalili, he says, forget it. No bitzua, because bitzua means we're not going to investigate the matter as thoroughly as we would with a beis din. And therefore, this guy who's looking for a compromise might get something that he's entitled to. And my friends, this is not so dissimilar from people who bring frivolous lawsuits, and the defendant just says to himself, you know what, it's going to cost me tens of thousands of dollars to hire a lawyer and go through this litigation and fight it off. I can get out of this and be done with it for $10,000 and just settle, with this jerk who's trying to bring me a false action. So I'll just do it. And people make that decision all the time. Rabbi Eliezer is saying, don't do that. Don't do that. Stand on the principle and fight it, and don't engage in bitzua. He says bitzua is always bad. He would say, always go through the process of a beis din. Rather, the judge must assure that the true judgment, the true din, will prevail at all costs, and metaphorically, pierce the mountain. Never mind, feelings, facts, cost, time. Truth is the only thing. Pierce the mountain, says Rabbi Eliezer. And this is as it is stated, Deuteronomy 1:17, for the judgment is God's. And similarly, Moses would say, let the judgment pierce the mountain. But by contrast, Aaron, Moses' brother, whose role was not that of a judge. Moshe was the dayan. Moshe, right, was the judge, the dayan. Aaron, who's the Kohen Gadol, we also know him as what? The lover of peace, the promoter of peace. Aaron, whose role was not that of judge, was a lover of peace and a pursuer of peace. And he would apply peace between one person and the other, as it is stated from Malachi 2:6. The law of truth was in his mouth, and unrighteousness was not found in his lips. He walked with me, this is God talking, he walked with me in peace and uprightness, and turned many away from iniquity. The Tosefta cites several other interpretations of the above-mentioned verse from Psalms. Rabbi Eliezer, before it was Rabbi Eliezer, the son of Rabbi Yosef HaGalili. Now, Rabbi Eliezer, if one stole a seah of wheat and he ground it and baked it and separated challah from it, i.e. he separated the portion of the dough that must be given to the priest, how can he possibly recite the blessing on the mitzvah of challah? How can you make a mitzvah? How can you fulfill your obligation and get the zechus, the credit, the merit that comes from performing a mitzvah, if you're fulfilling your obligation, performing that commandment with stolen something, stolen bread, stolen esrog at sukkah, at Sukkot, if the candle, even lighting Shabbos candles with a stolen candle, how can you get credit for performing a mitzvah if the thing you're using to perform the mitzvah is stolen? So says Rabbi Eliezer, he is not blessing when he says, he can't say a blessing on something that's stolen. Rather, he is cursing God. If he utters a blessing over a stolen object in order to perform a mitzvah with it, he is not blessing God, he is cursing God. And of this offense it is stated, quote, and the covetous, uvotzea, blesses himself, though he despises the Lord. And this is interpreted homiletically as, and whoever blesses upon breaking botzea, the bread, stolen bread, despises the Lord. Right? So somebody thinks, well, I'll just steal it so I can make this bracha, and finally, it's like the thief who's thinking about mending his ways, and he says, well, I could start by making a blessing on the bread that I stole. No, if you stole it, and you can't perform a mitzvah with it, and if you say a blessing over something stolen or prohibited for other reasons, it's like cursing God. Now, let me read to you what the Shulchan Aruch says about this. If one eats a forbidden food, whether it is forbidden by Torah or rabbinic law, he neither recites a blessing upon it nor participates in the invitation to join in the grace after meals, the zimun, for such food. And with regard to such a person, the verse says, and the covetous blesses himself, though he despises the Lord. Even if it's just prohibited by laws of kashrus, it's bad enough if you eat it if you're a Jew. don't say a blessing on it. If someone stole wheat and ground it and baked it, some say that he may recite a blessing upon this food, as through effecting a physical change to the wheat, he acquired it. He still has to make good on what he stole, and he's going to owe the double payment. But now that he turned the wheat into bread, maybe that bread is no longer what he stole. He has an obligation to replace what he stole, but some say he can say a blessing on this bread. Some is certainly not all or even the majority. Others, and this includes Rashi and Rambam, say that even though he has acquired the wheat through its physical change, it is still prohibited to mention God's name in relation to an item that is acquired in a forbidden manner. Okay, let me get back to where I am. Rabbi Meir. Now we've had two opinions. Rabbi Eliezer, the son of Rabbi Yosef Galili, and we had Rabbi Eliezer, now Rabbi Meir. Rabbi Meir says, we're talking about, is it permitted to do mediation, bitzua? Rabbi Meir says, the term botzea employed in that verse was stated only with regard to Judah, Yehuda, right? The son of among the 12 sons of Jacob, from whose descendants comes King David and eventually will come Mashiach. What about Judah? What about Yehuda? As it is stated, and Yehuda said to his brothers, what profit? And the word is bitzua. What bitzua is it if we slay our brother and conceal his blood? Come and let us sell him to the Ishmaelites. That was in last week's parsha, last week's Torah portion. And consequently, anyone who blesses Yehuda for this act is cursing God. And of this it is stated, and the covetous, uvotzea, blesses himself, though he despises the Lord. Interpreted homiletically as, and whoever blesses the profiteer, botzea, despises the Lord. Now Yehuda was saying, let's not kill our brother, let's just sell him into slavery. But he was talking about botzea, we get something for ourselves. One thing we get for ourselves is we didn't murder our brother, but the other thing we get for ourselves is the silver that they got for selling him into slavery. Rabbi Yehoshua ben Korcha says it is a mitzvah to mediate a dispute. It is not only permitted to do bitzua, mediation, precise compromise, right? Precise arbitration. It's a mitzvah. It is a mitzvah to mediate a dispute, as it is stated, execute the judgment of truth and peace in your gates, from Zechariah 8:16. Is it not that in the place where there is strict judgment, there is no true peace? And in a place where there is true peace, there is no strict judgment. Rather, which is the judgment that has peace within it? You must say this is mediation. Din is din. Strict justice, just din by itself. Unadulterated din is just whatever the law would require in this case. Din that has shalom in it, peace, shalom, din with shalom, what is that? Bitzua. And similarly with regard to David, King David, David HaMelech, it says, and David executed justice. And here it's mishpat, right? Mishpat, a word we often use for certain kinds of statutes and laws. But here it's mishpat, mishpat utzedaka, ose mishpat utzedaka. Right. Okay, very good. It says mishpat utzedaka. Okay, so David executed mishpat and tzedakah. So mishpat now is translated here in the Quran into English as justice. Okay, so application of the law, what we've been calling din. And tzedakah, which we often translate as charity, and here is being translated as charity, but it's also righteousness, right? Doing things rightly according to the Lord, righteous according to the Lord. Okay, but mishpat utzedakah, justice and charity. King David would do a combination of justice and charity. So what is mishpat and tzedakah? It's being compared to din and shalom. And is it not that wherever there is strict justice, now using the word mishpat, there is no tzedakah, and wherever there is tzedakah, there is no mishpat, right? If you're going to just go to make sure you're being kind to people, you're not going to have strict justice. And if you have strict justice, you're not going to be, emphasizing and prioritizing being kind to people. Those two things don't go together necessarily. They can produce different results. So rather, which is the mishpat that has within it tzedakah, you must say this is bitzua. Right? So mediation, where we're cognizant of maybe what the ultimate end would be, but we also just want to have a result that we can all live with and get through and go back to our homes and our businesses and our lives in peace. Now, the Gemara cites an alternative interpretation of David HaMelech's method of judgment, in which we come to the opinion of the first Tana, Rabbi Eliezer, son of Rabbi Yossi HaGalili. He's the one who said, no bitzua, no mediation, no matter what. Only din. How can he get the same teaching out of the fact that David says, mishpat u'tzedakah? If a judge adjudicated a case of monetary law, and he correctly exonerated the party who was exempt from payment, and he deemed liable the party who was liable to pay, if he then saw that due to his ruling, a poor person became liable to pay an amount of money that is beyond his means, and therefore the judge himself paid for him from his own house, this is mishpat u'tzedakah. Right? So interesting. He applied the law properly. But when you apply the law properly, the poor one owes the rich one money, and the poor doesn't have how to pay. So the judge steps in and pays it for him. He gave the judgment properly, but out of his goodness of his own heart, he's going to help the poor person pay it off. Rabbi Eliezer, the son of Rabbi Yossi HaGalili, says that's mishpat u'tzedakah. Now, it is justice for this one and charity for that one. It is justice for this one because the judge restored his money to him. He was entitled to the money. And it is charity for the other one because the judge paid it for him from his own house. And similarly, with regard to David HaMelech, it says, and David executed mishpat u'tzedakah, justice and charity, to all his people, from 2 Samuel 8:15. He executed justice for this one because he restored his money to him, and charity for that one because he paid it for him out of his own house. But this interpretation of that verse is difficult for Rabbi Yehuda Hanasi. If the word charity, tzedakah, is meant to demonstrate that David supported the poor defendants, well then this term, to all his people, would be incorrect. Right? If you're saying, okay, well he helped out the poor by paying things for them, even though that they needed to pay by right and by law, they needed to pay, but he helped out the poor people, well then he did tzedakah for the poor. He didn't do it for all people. And this said, the verse from 2 Samuel says he did this for all people. So what does that mean? If this interpretation is correct, it should have stated charity to poor people. So rather, Rebbe says, although he did not pay from his own house, it is still mishpat u'tzedakah. It is still justice and charity. It is justice for this one and charity for that one. It is justice for this one because the judge restored his money to him. He was entitled to get that money. The judgment was correct. And it is tzedakah. It is charity for that one who lost, and it's going to be very difficult for him to pay the judgment. It's charity for him. Why? Because the judge removed the stolen item from his possession. By adjudicating the case correctly and compelling the liable party to pay his debt, the judge thereby ensures that the liable party does not illegitimately maintain property to which he is not entitled. Yeah, it's a benefit to you to receive a correct judgment, even though it hurts. Because what are we all doing here? We're all building our chelik, our portion in Olam Haba, in the next world. And we don't want to possess and enjoy the benefit and fruit of anything to which we're not legally entitled. If we're holding on to property that we owe to someone else, that we should have paid back, that we didn't give them their part of it, that we just kind of like didn't do the analysis properly because, maybe deep down we suspected how it would go, etc. If we stole something, some kind of gray area deal where it sounds good. No, it's not stealing. It's definitely not stealing. It's not like I walked into his house and took it. But the law is very unclear in this area, and I don't think I need to pay him that. And the judge comes in and says, you need to pay. And then you pay. It hurts. It stinks. It might be really difficult. But he did you a great tzedakah. He did charity for you because he took something that's not yours out of your possession. And that's a big benefit to you in the big game, right, of eternal life, where we're going to be held to account for anything that we didn't do the right way while we were here in this mortal life. It's tzedakah for him to lose that case. Rabbi Shimon ben Manasseh says, if two litigants come before you for a judgment, before you hear their respective statements and claims, or after you hear their statements, but you do not yet know where the judgment is leaning, meaning that it is not yet clear to the judge which party is in the right, then you are still permitted to say to them, go out and make bitzua, mediate, accept some kind of compromise. It can be a precise compromise, but don't wait for the judgment that I don't know which way it's going to go. I'm telling you, you don't need to go through all that process. You can get to a more peaceful outcome right now. But after you hear their statements and you know where the judgment is leaning, then you, the judge, are not permitted to say to them, go out and mediate. As it is stated, the beginning of strife is as when one releases water. Therefore, leave off contention before the quarrel breaks out. Proverbs 17:14. So Rabbi Shimon ben Manasseh interprets the verse to mean, before the resolution of the contention is revealed, you can cast it off. Once the resolution of the contention is revealed, you cannot cast it off. So if you've heard both sides as a judge and already you have an instinct which one is right, even though you haven't done all the research, let's say, already it's too late. But before they finish making their statements, or even if you've heard their statements, but you know what? You don't know. You really have no idea which is way it's going to come out because you have a lot of research to do, then it's still not too late. But as soon as you, the judge, have a good feeling for which way this is going to go, it's too late to recommend to them to do bitzua, to do mediation. Now, that was Rabbi Shimon ben Manasseh. Now, the next opinion, is bitzua permitted? Reish Lakish says, if two litigants come for a judgment and one is flexible and agreeable and the other is rigid and contentious, before you hear their respective statements or after you hear their statements, but you do not yet know where the judgment is leaning, it is permitted for you to say to them, I will not submit to your request to judge you. The judge can recuse himself. The judge may refuse the case out of fear that perhaps the strong and contentious one will be found liable, and it will turn out that the strong one will pursue the judge with intent to harm him. And there's pekuach nefesh. The judge feels it's going to be dangerous for him to judge this case because one of the litigants is a gangster, and he doesn't want to be pressured into giving this guy, a judgment that doesn't go against the gangster. Maybe the gangster is right. But if it's, enough of a fear that if it doesn't go the gangster's way, that the gangster is going to imperil the judge can say, you know what, I'm not going to judge this case. This case is not for me. As long as before you hear their respective statements or after you hear them, but you still don't know which the way the judgment is going. But says Reish Lakish, once you hear their statements and you know where the judgment is leaning, then you may not say to them, I will not submit to your request to judge you. As it is stated, you shall not be afraid before any man. Deuteronomy 1:17. You could walk away before this case starts. But once this case starts, the fact that one of them is a gangster, you have to stand up to, you have to do your job as a judge. Rabbi Yehoshua ben Korcha says, from where is it derived that a student who is sitting before his teacher and he sees a point of merit for a poor person or a point of liability for a wealthy person? From where is it derived that he should not be silent? Now, usually a student cannot say what the law is when he's sitting or standing in front of his teacher, his rabbi, his rebbe, right? The student must be silent when his rebbe is judging or is issuing statements, halakhic rulings of what is pure and what is impure, what is ritually right or wrong, etc. But if it's in a situation of a beis din, if it's in a court situation, and the student catches something that maybe his teacher missed, but it could result in the wrong party, right, having to pay, or the wrong party getting, especially in a capital case where if it goes the wrong way, the defendant who's accused of a capital crime could end up with the death penalty. So in these cases, the student is obligated to speak up even before his teacher, where, for example, if his teacher was teaching just a lecture of Torah law, the student would never stand up and say, Rabbi, I think you got something wrong. Never. But when a defendant's verdict is on the line, then the student is obligated to speak up. And how do we know this? As it is stated, you shall not be afraid before any man. He should fear neither his teacher nor the wealthy litigant. And Rabbi Hanan says the verse intimates, do not suppress your statement before any man. And the witnesses should know about whom they are testifying and before whom they are testifying. They should know about whom they are testifying, right? They should know who it is that they're saying, this guy killed that guy, this guy lent money to that guy. They should know who it is that they're talking about. They should know the names. By the time they come to trial and give their testimony, they'll know who these people are. And they should know before whom they are testifying, before whom with a capital W, meaning that they're standing before God. When you give testimony in court, there is nothing more serious. And when you as a judge give judgment in court, there is nothing more serious. And the judges should know, first there is a verse from the Torah, then both the men between whom the controversy is shall stand before the Lord. Right? You should know about whom you are testifying and before whom you are testifying. And the judges should know whom they are judging. They should know the names and identities of the people that they are judging and before whom they are judging. Again, and the judges should know whom they are judging and before whom they are judging and who will ultimately exact payment from them. All of this is being done before God. God might not speak up, usually doesn't. In any court of law, God is the strong silent type, but we are all accountable before God. God is the ultimate judge and king of the world. Everything goes according to his will in this world and the next. And somebody who perverts justice in any way will have to account for that before God. If not in this world, then in the next. So the judges should know whom they are judging and before whom they are judging and who will ultimately exact payment from them. As it is stated, God stands in the congregation of God. God stands in the congregation of God. Psalm 82, verse 1. And similarly, with regard to Yehoshaphat, it says, and he said to the judges, consider what you do, for you judge not for man, but for the Lord. 2 Chronicles 19:6. And lest the judge say, well, what value is there for me with this suffering? Why should I engage in such a burdensome and difficult task as being a judge, now that if I make a mistake, I might be personally liable? If I do it right, a gangster litigant might blame me for giving that judgment and come after me. If I get it right, there might be a mob outside who thinks I got it wrong. Why should I put myself through that? The verse states, quote, he is with you in giving judgment, from which it is derived that in rendering his decision, a judge has only that which his eyes see. He is enjoined to render the best judgment possible based on the information that he has available, and he is not accountable for anything else. He has God, he has his judgment, and he's not going to pervert judgment, not for the rich and not for the poor, not out of fear, not out of greed, not out of anything. Earlier, the Tosefta stated that once the verdict has been issued, it is not permitted for the judge to arrange a compromise. Now, the Gemara asks, well, what are the circumstances of a verdict? I.e., I'm almost done. Questions or comments, please get them in now. What are the circumstances of a verdict? I.e., again, what are the circumstances of a verdict? I.e., what is the formal action that signifies the conclusion of the case? Rav Yehuda says that Rav says, it is when the judge says, so-and-so, you are liable, and so-and-so, you are exonerated, or so-and-so, you are exonerated. Rav says the law is in accordance with the opinion of Rabbi Yehoshua ben Korcha, who said, it is a mitzvah to mediate a dispute. And the Gemara asks, well, is that so? And was it not that Rav Huna was a student of Rav? And when litigants would come before Rav Huna, he would say to them, do you want a din, a strict judgment, or do you want a peshara, a compromise? So interesting. He would ask them that. Do you want a din, or do you want a peshara? Now, this sounds like he already knows what the outcome is going to be. He's not giving any clue to them, but he's asking both litigants, do you want a din, strict judgment, or do you want a peshara, a compromise? So evidently, Rav's student, Rav Huna, did not hold that it is a mitzvah to specifically arrange a peshara. He's giving the option to the litigants. And the Gemara clarifies, what does Rabbi Yehoshua ben Korcha mean that he says it's a mitzvah, a commandment to make a peshara, to make compromise? What does that mean? Now we're at the top of 7a. He means that it is a mitzvah to say to them, it is a mitzvah to give them this choice. Do you want din, or do you want compromise? Do you want peshara? So the Gemara objects, well, since this opinion is the same as that of the first Tana, who also allows peshara, compromise, it is redundant to teach it. The Gemara answers there is a difference between them with regard to the question of whether it is a mitzvah to arrange a compromise. Rabbi Yehoshua ben Korcha holds that it is a mitzvah to offer them the option of compromise. But the first Tana held that it is merely permitted to offer. It's permitted to offer, or you're obligated to offer. And the Gemara objects, well, if so, the opinion of the first Tana is the same as Rabbi Shimon ben Manasseh. The Gemara answers that there's a difference between them with regard to the principle. After you hear their statements and you know where the judgment is leaning, it is not permitted for you to say to them, go out and make bitzua, go out and mediate. In that instance, the first Tana holds that it is still not too late to suggest the mediation. So we haven't really, there's different opinions about how late in the process can you offer bitzua or peshara. Once you already know which way is leaning, can you still give them that choice? Do you want a strict judgment? One of you might be unhappy, or do you want to compromise, peshara? And how late in the process can the judge offer that? And is the judge obligated to offer that, or is he merely permitted? That's where we're going to stop and take a few questions before we sign off. Okay, Bill, since you sounded a bit surprised that I was here tonight, never fear. I've got 2 hours before tonight's service starts. Can't think of a better pregame than learning Talmud. Thank you, Bill. Always great to see you and discuss with you. Yosef, would it be fair to say that individual sages may be wrong, but not as a majority? Well, it's interesting. We haven't even talked about that. Like, what happens when a court of 3 ends up making a mistake? Well, if what they ruled was violates an explicit Mishna, sounds like it would not be a judgment, even with 3. I'm not sure about that. Certainly with less than 3. But maybe even with 3, it would not be a judgment because it just violates clear law. If it's a matter of deliberation, they got the law wrong as it's normally held, or some other kind of a mistake, sounds like what they did, they did. And, since it was a court of 3, I don't think that they have to pay for it out of their own pocket, but it might be that it depends where they got their authority to sit on that court, or it might also be that even though it's a din that they're offering, did the people accept to be in that court or were they compelled? I don't know. There's some open questions there. Bill, question about blessing forbidden food. The law does not allow kashrut to be set aside if a life is in danger. If a Jew were on the brink of starvation and managed to acquire non-kosher food to avoid their fate, can they then say a blessing over that meal? Sharon gave an answer. I would guess not a food blessing, but perhaps a shechechianu, the blessing for keeping one alive to experience that moment. We will be saying it tomorrow for the first night of Hanukkah. I'd have to, it seems to me like it's no, right? You can eat the food to save your life. You can certainly eat the food to save your life, but you shouldn't make a bracha over it. I think it's interesting what Sharon suggests, but you can make shechechianu because your life was saved by that food. I like this outcome. I have to actually ask my Rav, what is the outcome in this? But I like this analysis, and I suspect, Sharon, you got it right. Jonathan, tzedek and mishpat. I would note the daily prayer of the Amida includes a prayer, din, for God to be king over us alone, and gives tzedek and mishpatim, tzadkenu b'mishpat. Exactly. He is a ruler, who is praised for both attributes, right? God, in fact, what is it that God prays for, right? There was once one of the, forget the name of the Kohen Gadol, I think it was Rabbi, I'm sorry, it was the Kohen Shimon HaTzadik, I think, or maybe it was Yochanan. It was a Kohen Gadol who was incredibly righteous and got to ascend to heaven, I think during Yom Kippur, and they asked him, and he was able to talk with God and or see God, what God was praying for, and they asked him, what does God pray for? And he says, God prays that his attribute of mercy will overcome his attribute of strict judgment, of din, right? Because, we're all so burdened by our yetzer hara, by our evil inclination, that really, if God was always dispensing din, or gevura, strict judgment, who could survive, right? So thank God that God is so merciful. Thank God that God is so merciful, and we're supposed to walk in the ways of the Lord. So that's why we always want to temper, right, our din with shalom, or our mishpat with tzedakah, our gevura with chesed. These are all related concepts. Gevura, judgment, with chesed, loving kindness, always tempering, right, strict justice with mercy, with compassion, with kindness, just as God does, right? See, these are forces that are balanced, but if one has to overcome the other, chesed should overcome gevura. Bill, now hold on. So we're saying that if the judge has a sense of how he will rule, he can't recommend mediation, according to one of the opinions. But we're also told that there must be one standard of law for all. That seems to be at variance to me, because some judges might be more naturally reticent or cautious in their rulings and form their opinions slower than some of their peers. True, but I think as a principle, not bad, right? That what we don't want is that once the judge knows which way it's going to go, he's like, trust me, you want peshara, not din, right? Once he knows his communication, it's like he knows something they don't know, and it's much more clean if we say he can only offer the option of peshara before he knows which way it's going to go. Because then in communicating to them, hey, take peshara, not because I know which way it's going to go, but I'm just advising you as, somebody who's older, wiser, know the ways of the world and of Torah and of God. I suggest go for peshara. You'll walk away happier. But once he knows which way it's going to go, it's not a bad idea. Now, another opinion says, no, even when he knows what the judgment is, he could still offer them peshara. And finally, Jonathan, about testifying, about witnesses testifying. I read a treatise recently about Jewish opinions of lying. The one place it is never allowed is in the court. Somewhat okay in other instances, especially if lying can save your life or someone else in danger, also for shalom bias. Exactly. So there's an opinion like, if your friend is marrying, somebody and their new spouse is very unattractive. So do you say that in case we're talking about the bride, for example, do you say to this groom, oh, your bride is beautiful. She's so beautiful. Even if she's not, so Beis Shammai would say, find something else to compliment. Beis Hillel say, yeah, you tell the groom she's beautiful. And so other little nuanced lies, your spouse makes a dinner, works really hard on the dinner for you. You take a taste, it's terrible. You say, so good. I really appreciate you made this for me. That's for shalom bayis. That's for peace in the home. That's permitted. But in court, where you're testifying, and according to what you say in court, din will be given. No lie possible. That's what I've got for us tonight. And with God's help, we'll be together again tomorrow, Wednesday, at the regular Wednesday time, 6 p.m. Pacific. Have a good night. Have a great day.